A lot of people have been upset by the deals that those big law firms have cut with the Trump administration. But are those agreements actually enforceable in court? Let's discuss. I'm Dave Aronberg, former state attorney for Palm Beach County, aka the Florida LawMan, here on Legal AF. Thank you for all your support, and thank you for all your subscriptions. It's been really a booming enterprise, this Legal AF. So hit that subscribe button. I'm not sure if I'm pointing in the right direction. I'll do this way too. Maybe it's there, but hit that subscribe button and let's keep this ball rolling. So now let's talk about those law firms. Big Law, which has been capitulating to the Trump administration. Remember, Trump wanted to go after those big law firms because they employed people who went after him. You had Mark Pomerantz here as a lawyer who went after him. You had Andrew Weissman there, and so he's going after the law firms that employed them. And clients of those law firms are worried that they're going to be punished. And also law firms are worried about government contracts they're going to lose. And so you have some of these law firms cutting deals. And that's been disturbing because if you can't count on the law firms who are supposed to be fighting on your behalf against an encroaching executive branch, then who's going to defend you, right? If the law firms themselves are going to cut deals, then who's going to be in your army, right? If your army is selling out to the other side. So there is some hope, though, because some of the legal scholars have recently put out a piece that says it doesn't matter, that the president cannot enforce these law firm deals. They're unenforceable. So we're talking about the law firms together committing nearly $1 billion in pro bono legal services. Now, first off, really? Do all these groups that get, like veterans groups, groups that fight anti-Semitism, could they use $1 billion worth of pro bono legal services? That's a lot of hours. That's probably way more than these groups can even handle. And so as an initial matter, a lot of this is for show, not much for go, because really, is there an enforcing agency? Is there an agency that's monitoring this? No, of course not. This is about getting the deal, announcing in front of the cameras that these law firms capitulated, Trump can take his victory lap, and then the law firms go home and do what they normally do, which is bill hours and make a lot of money. Now, there is an issue, though, with the agreements themselves. In addition to the fact that there's not going to be really any compliance to it, we have to go into the question of what exactly did these firms agree to. Now, in an article in Just Security, they go into the basic questions about what law governs, who are the parties, did the firms contract with Trump himself or with the U.S. government? But the biggest question is, are these law firm deals enforceable contracts? And that's what we do at Legal AF. We're at the intersection of law and politics, although I add on true crime. We'll get to true crime videos another time. This one is about whether these deals are even enforceable. A contract has to be a meeting of the minds, okay? And it looks like, though, when it comes to these contracts, that Trump has a very different impression of them than the law firms do. Remember, Trump put out a press release about how the one contract was, or this one agreement was, that the law firm admits that their lawyer, Mark Pomerantz, acted improperly when he helped prosecute Trump in that New York hush money case. When the law firm then said, no, we didn't castigate one of our own former partners. That's not part of the deal. So it looks like there was not a meeting of the minds. So that would void the whole thing. In addition, there's the part about the legal fees. Now, according to Just Security, Trump continues to tout the fact that he has a lot of legal fees at his disposal and that he might as well use them. He and his subordinates have floated such varied possibilities as having the firms negotiate trade deals, draft coal leasing agreements, and represent him personally. As several internal statements make clear, the firms clearly did not see indentured servitude or ceding government control of their pro bono commitments to be part of the deal. The contract law requirement of definiteness is well settled. If the parties are so far apart on the key term of the deal, was there really any meaningful agreement at all? Second, a contract without consideration is unenforceable, something the law calls an illusory promise. So consideration is what you get in exchange. That's how you have like contracts where you have people turning over, here's $1 in exchange for your property, that kind of thing. It has to be some sort of give and take, some sort of consideration. Consideration requires each party to surrender something of value. on a legal right they otherwise possess. But if the president, according to Just Security, retains full discretion to reissue executive orders or again direct EEOC investigations at any time, even if capitulating firms follow their agreements to a T, then the president has surrendered no legal rights or powers. His tweeted promise not to target a capitulating firm is worth nothing. It is merely a statement of present intention, not a binding commitment that limits his future actions. Yeah, it's not consideration if one side's saying, I won't arrest you. When, arrest you for what? I won't be mean to you. What does that mean? What's the give and take here, right? Just saying you can arrest someone for nothing or saying that you're going to be mean to them on social media, that's not really true consideration in return for $1 billion in pro bono legal services. And then finally, the illegality of the punitive executive orders opens the door to a challenge on public policy grounds. Courts are not timid in voiding contracts contrary to public policy in the United States as manifested in the Constitution. The 4 law firms that challenged the punitive executive orders quickly won temporary restraining orders blocking the orders from taking effect. The tenor of subsequent court hearings suggests that the challenging firms are now steadily moving toward securing permanent injunctions. No court would have approved deals coerced by these illegal executive orders as consent decrees, subsequently monitored by judicial oversight. These blatant constitutional defects, both in the original executive orders and any new orders the administration might issue against breaching firms, suggest that these deals may also be voided as offensive to public policy. So, Just Security is asking them what's next, if they can be set aside as unenforceable. What happens next? Well, obviously, firms should not enter into these agreements to begin with, right? I mean, they're entering into an agreement that they have to know is unenforceable. Maybe they're being so cynical saying, you know what, we know this is garbage. We're doing this just to get them off our backs. I'm sure that that's a conversation they're having inside the law firms, but it sends such a terrible message, not just the legal world, but to the entire country, that we're capitulating. And in return, we're going to get off their enemies list. Well, that's like the law firms, looking out for themselves at the expense of others, including our democracy. But also, the settling law firms, according to Just Security, now have a second chance to reassert their independence. They can and should assert that these agreements are not enforceable. It is not enough to say vaguely, as a number of these firms have, that they continue to stand by their values. Instead, the firms should take specific, concrete actions to make clear that they still choose their own clients and cases. And then also the settling firms should consider the potential costs of continuing to do the administration's bidding. The settling firms will find no safe harbor if they continue to carry out their part of the bargain. Yes, I do think that history is not going to treat them well. After this period of history is over, I think that we're going to look back and say, remember those law firms that were supposed to defend us against encroachments of our democracy, against an overly oppressive executive branch? Well, those law firms joined that executive branch, even though they knew that those contracts would never be enforced. That's not a good look. And I think it's going to hurt their recruitment efforts in the future, not just for clients, but also for employees. Now, perhaps these law firms had other reasons to it, but it seems pretty clear that law firms that are used to litigating, law firms that are used to fighting, that it's not a good look for them to look like they're on their knees. And so perhaps they now have a chance, based on these factors, to stand up and say, we're not capitulating any further. These contracts are unenforceable. Whether they do it or not, it's up to them. But it's also up to the people who hire them and the people who want to work for them and the people in the general public who can speak out and speak up. And I think we're seeing that more and more in our country. And of course, we're always seeing it here on Legal AF. I'm Dave Aronberg, aka the Florida LawMan. If you like this video, please like, subscribe, share with a friend, leave a comment below. Thank you for all your support, and we'll see you next time.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.